Hi, I'm Wendy with MobiliQuest, and we are here today doing our first segment with something called Expert Insights. So what we're going to be doing is talking to experts about anything and everything related to mobility issues, elder issues, things that we hope can be useful for you. So today I'm here with Jason McCart of the McCart Law Firm, and we are going to be discussing documents that you would need, especially as you get older. Everybody knows about a will, but there are other documents beyond that. And Jason is going to inform us about what those documents are and exactly what to do with those. So I'm going to hand it over.
All right. Well, thanks, Wendy, for coming over here and talking to me. Appreciate it. Appreciate the opportunity to talk to all of you today. First and foremost, I want to say something. We're going to be discussing legal documents, legal ideas. We're going to be discussing the law, and I just want to be clear that. What I discuss today is really for informational purposes. Don't take what I'm going to say to you in the video today as me giving legal advice. This is informational. If you need legal advice, please reach out to an attorney to discuss your specific situation and your specific issues. Today's information is just that information, and just kind of gets you thinking about what you might need to have in place before it's potentially too late for you to sign legal documents and to prepare your estate. But that's what we're going to do today. Just kind of give you a little bit of an introduction and discuss some of those ideas and mechanisms for estate planning.
Perfect.
But like you said, Wendy, everybody knows about the will. Mm-hmm. A will, in case you don't know, is a legal document that says what happens to your property in the event that you die. Mm-hmm. It allows you to specify who gets that property in the event of your death versus you dying and you don't have a will, and the laws of the state of Georgia or the laws of whatever state that you live in that decides who gets your property. Mm-hmm. Those people would be your legal heirs, and so most people don't want to just leave it to the state.
No.
And especially in the time that we're in now, where blended families are becoming more and more common. Mm-hmm. In the event of a blended family situation, it's really, really important to have just even the basic will in place, because if you don't have a will and you have a blended family, it really can lead to unintended consequences of what happens to your property. It can lead to a situation where a stepdaughter or a stepson that you've cared for their whole lives almost. If you die without a will and you haven't legally adopted them, for example, they could be left out of inheriting from your estate. So that's why it's important to even just have a basic will in place, especially in situations where there's a blended family. In addition to a will that disposes of your property, as we age, we get to the point where we need to have people help us, and we have to sometimes have legal documents in place to give people the authority to help us, with our finances or making decisions for our health care and things like that. And that's where some of the additional documents can come into play. Georgia, has a statutory form. Statute meaning statute. The statutes that are in place. They have a statutory form, financial power of attorney that really anybody can print. But sometimes it takes a lawyer to explain what it means, and that's available for people either through an attorney like myself or to find on their own that statutory form to state and indicate who do I want to take care of my financial affairs for me if I'm not able to. If I can't make decisions about my finances anymore. That's what a financial power of attorney, a statutory financial power of attorney, can do. It's something where you don't even have to give your agent, is what it's called. You don't have to give them just carte blanche, full authority over every single thing.
Right.
I mean, you can give them authority to just control your bank accounts, or you can give them authority to just handle your real estate matters, or you can give them authority over everything you can think of. It's really kind of up to you and how much authority you want to give to your agent that you have listed in the power of attorney. But as we age, we have to have somebody lined up, and really preferably somebody behind them lined up to be able to handle your affairs if you become incapacitated or just really can't make decisions for yourself legally. Another type of document that people want to have in place is called a durable power of attorney for healthcare, also known as a healthcare directive. That's a document where you can name somebody to be your agent for purposes of making decisions for your healthcare, but also it goes beyond that and tells that agent or doctors, nurses, other healthcare staff, if I get to a situation where I can't make decisions for myself, I cannot communicate those decisions for myself of what kind of healthcare I want, and I'm in a situation where I have a terminal condition, my death is imminent. Do I want to be kept alive with machines? Do I want to be kept alive with artificial feeding through feeding tubes or IVs for hydration? Do I want all that, or do I want to just be allowed to die in a natural, dignified manner? That healthcare directive allows you to make those decisions for yourself, what you're comfortable with ahead of time, so that the people, your loved ones, or your friends who are taking care of you or trying to make decisions for you, it gives them direction and it gives them some peace of mind, so that they know that even if they are telling healthcare staff to remove these life prolonging measures, that you as the person making those decisions, that you're following that person's wishes. That's another important document in addition to the financial power of attorney. I kind of describe that as kind of a healthcare, a power of attorney for your body versus your finances. And really, those three documents, a will, a financial power of attorney, and a healthcare directive, those are the core documents that I offer to people who are coming to me for estate planning purposes. At a minimum, that's what I recommend that people have in place, for their estate planning.
Okay, perfect.
Yeah.
Okay, so some extra questions for you. So thinking about if the person is elderly and maybe has Alzheimer's and has a caregiver, is there extra documentation that they need to have related to what if the caregiver passes first? What happens to the person that has Alzheimer's? What can they do to sort of get ahead of that so that they're not, somebody doesn't last minute have to deal with that sort of thing?
Right. That's, in my opinion, a perfect situation to think about setting up a trust. And we can talk about trust a little bit and then get to the kind of trust that would be. But I mean, people talk about trust. I want to put this property into a trust, and a lot of people, I don't think, really understand exactly what a trust is. What it means for property to be held in trust. some people talk about trust being an entity. Some people talk about trust, being a relationship. I kind of view it as a hybrid. When you think about a trust, what you're thinking about is an agreement between three people or three individuals, at a minimum. One is the grantor, the person who owns property, but they want to transfer that property into trust. They're going to transfer that property to a trustee, who is the person who is going to actually own the property that's being held in trust. And then that trustee is going to own that property, manage that property, and take care of that property for the benefit of a third person who is the beneficiary. And all of these things that or all these I guess you could call them rules, what the instructions to the trustee, how they're supposed to take care of the property, who they're taking care of it for, all this is set forth in an agreement called the trust agreement. That's setting out the relationship, identifying all the parties to it, and what property is going to be transferred and held under the rules of that agreement, which is the trust agreement. And so you have three people identified in the trust agreement, and for purposes of taking care of somebody who may be developing a debilitating condition, like Alzheimer's. In that situation, a special needs trust is an option, a good option. And what a special needs trust does is it basically transfers property to the trustee, and the purpose of that trust is the trustee to manage that property for the benefit and the care of the person identified in the special needs trust. And the trustee would be the friend of the family member who was initially identified to take care of that person. But the thing about trust is, if the initial trustee named in the trust agreement passes away, you can have already lined up in the trust agreement, I want this other person to be the successor trustee. And if you really want to be safe, you can name even a third person to be a successor trustee to the first successor, just to make sure that there's going to be somebody there to be able to make decisions and manage the property that's held in trust for the benefit of the person who needs the care, as long as they're alive.
Okay, makes sense. So I've heard that wills after death can be contested.
Yeah.
I do understand that. So as far as a trust goes, can a trust be challenged or contested or changed after that?
A trust can be challenged. It is a different procedure for challenging a trust versus a will. When you challenge a will, the executor who is named is going to have an original will, and they're going to submit that to the probate court for the probate court to declare whether it's the will. That is the actual probating of the will. Probate, meaning to declare that it's true. And so, to challenge a will, either an heir who has been kept out of the will, or any interested party. It could be a creditor of the decedent who passed away, with a will. They would file a challenge called a caveat in probate court to challenge the will, and it could be a variety of different reasons why a will could be challenged. One of the most common things is challenging that the person who signed the will had the mental capacity to sign it, or they were unduly influenced, or something like that. Just to challenge that this is a document that they signed voluntarily and that they knew what they were signing.
Right.
You can challenge a trust for similar reasons, but instead of challenging a will, what you're doing is you're challenging that agreement. Basically it's a contract.
Mm-hmm.
You're challenging a contract, and that kind of challenge has to be brought in, not in probate court, because a trust it doesn't go through probate. You would have to bring that challenge like you would any other contract challenge in court of general jurisdiction. Here in Newton County, Georgia, that would be in the Superior Court.
Okay. So it's a whole different process.
Yeah, it's a whole different process.
Is it more likely that a will would be challenged if it was, how to say this, more handwritten or someone that did it themselves versus a will that is prepared by an attorney? Or is there no difference as far as that goes?
Technically, if a handwritten will is signed and witnessed and notarized using the same, what's the word I'm looking for? In the same way as you would, a printed will.
Mm-hmm.
If it's witnessed by two witnesses and notarized by those witnesses, it's going to be just as enforceable as one that's done in my office.
Okay.
But
But knowing what you're doing to do it yourself.
But in practice, it's not going to be executed using the same formalities as what's required under the law for it to be less able to be subject to challenge versus if it's done in my office. And if it's a handwritten will and you have witnesses, but you have family members be the witnesses instead of independent third parties, like in my office, that's going to make it even more subject to challenge.
Right.
And most people who do a handwritten will, even if they have witnesses there, they're not going to have those witnesses sign a document, go in and giving their testimony that they saw the testator sign the document in their presence. And so, you're going to end up having to track those people down. Whereas having a will done in my office by my office, in our presence, we're going to have, in addition to the will, an affidavit that everybody's going to sign that makes the will what's called self-proving, which means those witnesses are stating that they saw the testator sign it, that the testator was of sound mind, and they did it voluntarily, and both of the witnesses were at least the requisite age to be witnesses in Georgia.
Mm-hmm.
And that's going to be notarized, and that means that the will then is self-proving, and you don't have to find the witnesses after the testator passes away for them to give testimony that they saw the person sign the document. You basically take that testimony at the time that the will is signed, and most handwritten wills aren't going to have those kind of formalities in place.
Right.
And not only does it make it harder to probate that will to declare it true, but also more subject to challenge.
Right. Makes sense.
Yeah.
Understand that. So we talked about a trust a little bit. Is there any other circumstances where a trust would be beneficial other than just for someone that had Alzheimer's, or is there a different situation that you could think of where a trust may be beneficial?
Well, let me think for a second. Both trusts and wills are estate planning options for people.
Mm-hmm.
Trust would be an option where somebody is trying to avoid probate.
Mm-hmm.
And so a trust would be potentially a more efficient mechanism for disposing of one's property, especially real property, and avoiding having to go through the probate process. Because if property is devised under the conditions of the terms and conditions of a will, and you have to probate the will and go through the probate process. I mean, that process in probate court, I mean, it can take, let me do the calculations of the timeline in my head. I mean, you could be looking at 6 to 9 months minimum before you're done with the probate process in court. And it could take, I mean, just for the first phase of probate, which is the appointment of the personal representative of the estate. In a situation with a will, it's the executor. There's not a will, you're still filing a petition in probate. It's for what's called letters of administration, but a personal representative has to be appointed to handle the affairs of the estate. And just the appointment phase can take anywhere from six weeks to 3 months sometimes. And if you're in a situation where that personal representative is needing to sell assets of the decedent, quickly, I mean, that can really put the brakes on, a transaction involving real property of a decedent. Whereas with a trust, everything's already transferred to the trustee. And so when when the grantor of the trust passes away, the trustee, assuming that the trustee is a different person, they already own the property. You don't have to go to probate court and get appointed. You already are the trustee. I mean, even if the trustee originally was the person who just died, you have in the trust agreement, that's where the importance of naming successor trustees come in. So the successor trustee can step in and handle the property and sell it if need be, or distribute it to beneficiaries according to the trust agreement. So a trust is more efficient. Both trusts and wills provide tax benefits to beneficiaries who receive property under a trust or under a will. I mean, it's called stepped up basis. Talk to your tax advisor about what might be more beneficial for purposes of transferring property to your beneficiaries or heirs. What's more beneficial from a tax perspective. But
meaning whether it's through a will or through a trust, yeah.
Okay. But they both do provide a mechanism of stepped up basis, where they get a better tax treatment than if you were to transfer the property to a loved one that you wanted to have, like for example, real property, transferring that to them while you're still alive. They don't get the benefit of that stepped up basis. And you could also trigger potential gift tax. So a trust is a more efficient mechanism to transfer properties at death. A trust is also a more private way to transfer property to beneficiaries upon your death. Because remember, a trust agreement does not get filed in probate court. It doesn't have to be probated. It's a private agreement. And so, trusts provide for people a level of anonymity, that you don't get with a will. Because if you pass away, you have a will, and the will is probated. Now the will becomes a matter of public record. It's a court document. It's a public record.
Okay.
A trust agreement is not.
So what do they, being a public document, when it goes to probate, is it printed in the newspaper? I mean, I know, as I understand, it's available as a public document at the courthouse, but do they put it in the newspaper anymore? How do they put that information out there?
Only the publication. The only publication would be the notice going out to debtors and creditors, and that the probate proceeding has been initiated.
Okay.
You don't actually see a copy of the will in the newspaper, but you do see notice that a probate petition has been initiated, and that process has begun, which would then lead one to go to the probate court and check a copy, get a copy of the will, look at a copy of the will if they wanted to. that's the kind of notice that would be published in the newspaper.
Gotcha, okay. Let me see. So so say there's a husband and wife still in the home together, and then one of them passes away.
Mm-hmm.
Does that home, that wouldn't go to probate? Explain how that works. So if their will goes to probate, but there's someone still in the home, how does that affect the property, if at all?
Well, we're talking about joint ownership of property by a husband and a wife. And in some states, just because two people are husband and wife, they're married, in some states they automatically basically own the property together with survivorship rights. That is not the case in Georgia. In Georgia, unless the deed, when the husband and the wife or the married couple acquired the property, unless that deed actually says that those two people own the property together as joint tenants with survivorship rights, then if the deed doesn't have that language in it, then the two people, whether they're married or not, they own the property as what's called tenants in common. And if one of the tenants in common passes away, then that person's half interest does not automatically go to the other person, even if they're married. It becomes part of their estate. That half interest becomes part of their estate, and that half interest would then be subject to their will if they have a will, or that half interest would end up getting inherited by the person's legal heirs if there's not a will, which can cause some hiccups if
I would imagine.
Yeah, if for example, the surviving spouse is trying to sell the property to downsize into a smaller space because they don't need to live there anymore, or for emotional reasons they don't want to live there anymore.
Right.
It can just cause a delay, because then you have to go through the probate process of your spouse who's passed away. But if a husband and wife own the property, or a married couple own the property as joint tenants with survivorship rights, then when one of them passes away, the other one automatically becomes the owner of the property. That half interest just automatically vests in the surviving spouse. And then when that person finally passes away, then that whole interest would be devised according to their will, or it will be inherited by their heirs if they don't have a will.
Okay. Thank you for that. I
Yeah.
appreciate you explaining that. I think that's about all the questions I have for today. Is there any other thing that you would like to mention?
Obviously, I talked a lot about real estate.
Yes.
And a lot of my practice, my legal practice, with probate, it seems to always be related to a real estate transaction. And real estate transactions are a lot of what my firm does as well. It's probably the majority of our practice. And, but I found that a lot of probate issues come up, during real estate transactions. And I wanted to make a point to incorporate probate work to better serve not only my real estate clients, but also people who need assistance with the probate process in general, and also preparing for that probate process with estate planning documents like wills, powers of attorney, healthcare directives, trusts if that's the route they want to go. All that is part of what we do at McCart Law Firm. But it is a lot of it is related to our real estate practice.
I thank you so much for taking your time with us today.
Thank you for coming here and letting me talk to you about this. And it's something I'm passionate about. And certainly, if anybody out there has any additional questions, or feels like they need to talk with an attorney more specifically about their situation, if not me, please reach out to somebody. discuss this because we're not getting any younger,
Right.
and it's not something that's pleasant to think about, but it's something that we all have to do. We all have to think about it. Yeah.
Absolutely. Unfortunately, we get to that point, don't we?
Yeah, we do. We do.
All right. Well, thank you so much again, Jason. I really appreciate it.
Thank you.
Thank you guys so much, and we'll see you next time.